So the lawyer doesn't have to agree to represent the client with respect to every single aspect of their case or claim. Okay. Comment 7 goes a little deeper. Although this rule affords the lawyer and the client substantial latitude to limit the representation, the limitation must be reasonable under the circumstances. Although an agreement for a limited representation does not exempt a lawyer from the duty to provide competent representation, the limitation is a factor to be considered when determining the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Again, see Rule 1.1. Comment number 9 discloses that there is a critical distinction between presenting an analysis of legal aspects of questionable conduct and recommending the means by which a crime or fraud might be committed with impunity. So start to think about this in the context of a client who may not want to report properly to Medicare for whatever reason, may not want to reimburse Medicare properly for past conditional payments, or may not want to properly set funds aside or ensure Medicare status as a secondary payer is preserved and protected post-settlement. We start to think about, how does this affect the attorney-client relationship? What type of advice must the lawyer provide? May the lawyer provide? What role do they play? And we get later on here, comment 13 gives a little bit of assistance. If a lawyer comes to know or reasonably should know that a client expects assistance not permitted by the rules of professional conduct or other law, or if the lawyer intends to act contrary to the client's instructions, the lawyer must consult with the client regarding the limitations on the lawyer's conduct. See Rule 1.4A5. Most often in the Medicare secondary payer context, this is going to come across as the potential for the client and the unwary attorney to perpetrate fraud against the Medicare trust funds, the Medicare health insurance program, for which the federal government has the ability to, desire to, and willingness to enforce the Federal False Claims Act under such circumstances. So 31 USC sections 3729 through 3733 are where we find the Federal False Claims Act. And as a practitioner who is thinking about Medicare secondary payer issues as part of your case or claim that you're working on, you have got to be aware of the False Claims Act and how this might come into play. So the False Claims Act provides that any person who knowingly submits or causes to submit false claims to the government is liable for treble damages plus a penalty linked to inflation.